From the Library of Congress in Washington, D.C.
Good afternoon, and welcome to the Library of Congress. I apologize for our late start, but I promise you will be rewarded for your patience. Members of Congress, distinguished guests, ladies and gentlemen, good afternoon. My name is Robert Newland, and I'm the Assistant Law Librarian for Legislative and External Relations at the Law Library of Congress. On behalf of the Library of Congress and James H. Billington, the Librarian of Congress, I welcome you here today for the symposium, Conversations on the Enduring Legacy of the Great Charter, which complements the library's exhibition, Magna Carta, Muse and Mentor. We are very fortunate to have luminaries in legal scholarship and the judiciary here to speak about the enduring legacy of Magna Carta. The library's exhibition, today's symposium, and a Law Library of Congress speaker series are all part of the library's participation in a series of global events commemorating Magna Carta. The exhibition opened to the public last month and is the culmination of 3 years' worth of work by divisions across the Library of Congress and in conjunction with our partners in England. The symposium is meant to extend the educational reach of the exhibition and to share new ideas about the impact of Magna Carta on American legal history and contemporary life. If you haven't already visited, I hope you'll take the time to head upstairs to the second floor and view the exhibition after today's event. Today's event is being recorded, and the resulting video will be available on the library's website free of charge as part of our ongoing commitment to lifelong learning. So that we may pay full attention to our speakers, we ask that you kindly mute all electronic devices. To maximize our time with you today, we will minimize introductions. Instead, please refer to the printed program in your hands for the backgrounds of our stellar speakers. You will be able to see the names of the individual panelists and moderators on the screen behind me as they come to the stage. We will first hear from Supreme Court Justice Stephen Breyer, who will be interviewed by David Rubenstein about American law and Magna Carta. Both of these gentlemen are keen enthusiasts of Magna Carta, and I know you will enjoy hearing from them. I present our first speakers. Thank you.
Justice Breyer, thank you very much for taking the time to do this. We're going to talk about the Magna Carta, but before we do so, I'd like to talk about a few other things because you rarely get a chance to interview a justice of the Supreme Court. So since I rarely get this opportunity, let me take advantage of it now and say that when you grew up in California and went to Stanford and then Harvard Law School, but did you always intend to be a law professor and then want to be a judge? How did that come about, to be a judge?
Well, go into law. My father was a lawyer. You may not remember this, you're not old enough. But there was a time when you sort of tended to do what your parents said. This is completely foreign to this entire audience, such an idea. But he was a lawyer, and then as far as becoming a judge is concerned, for any lawyer, a federal judge, lightning has to strike. I mean, it really does. And to be on the Supreme Court, it has to strike twice in the same place.
So you and I worked on Capitol Hill at the same time. I was working briefly for Senator Birchby in the Senate Judiciary Subcommittee on Constitutional Amendments, and you had come down to work for Senator Kennedy. Was that unusual for a Harvard law professor where you were then teaching to come down and work on Capitol Hill, and why did you decide to do it, and how did you like that experience?
Yes, it was unusual. It's odd. And it's still true to a degree. In the academy, there's this tremendous respect for the executive branch. If I had left Harvard and took a leave, as I did, I think to be a deputy assistant secretary of, you name the department, Oh, well, we understand that. To work on Capitol Hill? Why would he do that? Now, there was that attitude, spoken or unspoken, completely incorrect. I loved working in the Senate. It was fabulous, and I think it still is. As a staff person there, it's just, I'd get on my bicycle in the morning, I'd ride in. First thing we did when I was chief counsel of the committee, later at 79, 80, after you had left. You know, when you left, things began to go downhill slightly, but
Well, I was ruining things. Right. When I was in the White House, it was going downhill.
Yeah. No, but we'd have always breakfast. Who? Emery Sneeden, who was Thurman's staff person, chief person on Judiciary. Me, I was working for Senator Kennedy, who was the chairman then, and Ken Feinberg, who was like the number 1.5. All right? And we would plan the day. And the idea was, where legislation seemed desirable to enough people, you can color it red, so this group can color it blue, color it this way, color it that way. The object was to be able to present it so people of different political views could still vote for it. And we planned it, it worked. Kennedy's, I learned a lot from him, and he was wonderful to work for. And as you know, working for Birch Bayh, it was fun. It was interesting. You want to accomplish something good, and every minute, though, there are things that pop up, and it's a wonderful place to work.
It was a unique thing because there was a sense that you were actually supposed to work on legislation and pass legislation.
Yes, there was.
There was a very...
Correct.
But anyway,
at least try. Yes, no, we
so
did.
You're working, what happened, if you recall, in 1980, Jimmy Carter, my boss, lost massively to Ronald Reagan. And in that lame duck session that was then held, President Carter had nominated you to be a judge on the First Circuit. But the Republicans were going to control the Senate after Carter left, and so they really could block anything. How did you get to be confirmed in that lame duck, because the Republicans knew that they could have killed you in the next session if they just held it up for a while? So how did that actually come about? You got confirmed by an effective Republican Senate.
I think partly it's the way Senator Kennedy wanted this committee run. I mean, he wanted it run so there would be some kind of record of accomplishment. And that meant his favorite things to Feinberg and me. If I had to pick the phrase, 3 words, that I heard the most from his lips, work it out. That was our job. Right. Work it out. The first day I got there, he took me to the members of the committee, and particularly I remember going in the Republicans like the Democrats. He said to Alan Simpson, great senator from Wyoming, if you have any problems at the committee, Steve's going to be the chief counsel, phone him. And I felt that I was, of course, working for Senator Kennedy, but I was also working for the 17 members of the committee. And that's how we ran it. The other thing he said, which I've kept in my mind, is if you want to compromise, is you work things out by compromise, but a compromise is not, I'm here, you're there, we'll see what we can give up to meet in the middle. That's not compromise. The compromise is we don't agree about something, but we're trying to get together. I listen to what you say. Listen. And somewhere in this conversation, you will say something I think is okay. Then I say, what a good idea you have. Okay. Fabulous. I think we can work with that. And then we work with this idea. And then, if it goes through, the other thing he said is, don't worry so much about credit. It's a weapon. If in fact you pass it and it works, there'll be plenty of credit to go around. And if it goes nowhere, who wants the credit? So he'll push you in front, not himself. Don't worry about it. You will have the credit for your idea, which enabled us to compromise. That was his view, anyway. And I think we worked pretty much with that view for a couple of years, and I think perhaps the Republicans on the committee were a very good group, in my opinion, as were the Democrats. Birch Bayh was fabulous. I think they all got on pretty well. Now, I'm told it wasn't ideal, it wasn't paradise, it wasn't everybody just throwing rose blossoms around and so forth, but they did get on pretty well. And I think it was that, what I'd call a kind of collegial attitude that helped. And I just had drinks the other night with a group of staff Republicans and Democrats from the Senate Judiciary Committee. Now, it's only judging on the basis of an hour, but I would say things have not changed that much. They're enjoying it. Maybe they've changed to some degree, but you just see, you bring up certain things and what's your day like and what's actually happening during this day. There's more. There's more give and take, and there's more with friendship and so forth than I think sometimes we understand reading the paper.
So you got on the First Circuit. Strom Thurmond, the ranking Republican, basically said he's a good man and we can work with him. He's okay. Even though Senator Kennedy supported him, we'll support him. So you got on the First Circuit and had a very distinguished career. But one of the things you were most famous for is, as a judge, designing the new building that the court had. How did you actually feel you had the expertise to help design?
I personally did not design the building. Okay. We had an architect called Harry Cobb, who was the partner of I.M. Pei, all right? So it was Pei, Cobb, and Freed who designed the building. What I did do, and I with Doug Woodlock, who was the district court judge on it, is what I would call anyone can do. It's called take the time. And take the time meant that a day a week, probably, for 2 years, where we would work with GSA, the General Services Administration, and try to figure out how we're going to select the architect. We found the money to hire a consultant who was the secretary of the Pritzker Prize Committee, and he was great, and we went around, saw people's buildings, encouraged we wanted to make ourselves credible in the architectural world, and we had great people applying. And Harry did a terrific job, and I'll tell you one thing, we had to choose among 5, all right, or 6. Here's what he did. We're off the subject, but we're not completely off it. Because what he did is he showed us a courthouse in Virginia, a picture of 17th century Virginia courthouse, red brick, steeple, porch. And he said, look at that building. The porch is there because it is in the square, and it is a place for the public to meet. The steeple is there because it signifies a public building. That building works. The judge is there with his single courtroom. He's part of the network of people who are in the government who will help that government building to work for the community, and people will be part of it because it's part of the community. Now, I'll show you 3rd Street, Cambridge, or Los Angeles. What is that building? It looks to me like a hospital, or it looks like an office building. Or what is it? I don't know. The challenge is to take what's a public building for the public, where it's our organization, the judiciary, we're a high official, pretty high, a judge, a federal judge, meets face to face with the citizen who has the problem. And they engage in a kind of interchange so that rich, poor, whoever that citizen is, that judge will take the time personally to resolve his legal problem. That's an unusual institution. We want to express that in the building, but we've got to express it in a building that will be the home to 18 courtrooms, not 1. And how do you do it? And when we heard that, we thought that's our problem. How do we get the public to see that this is part of their government, that's not the division, they and the government? And Harry did a pretty good job of that. So in Boston, they do bring in the school children, and they do bring in the public for a variety of uses, and they do begin to chip away at this enormous problem that I think we have, which is how do we get those 18-year-olds to understand that this document that I carry around is not a document for me, it is a document for them. And we have a system where, in fact, the people of America will decide what kind of government they want within this document's framework.
Right.
And it's one that insists on a rule of law, and now we're back to the Magna Carta. And so now we're part of a world, and you're part of one, where we're trying to convince those high school students that they better understand this, and they should understand its history, and they should understand how that relates to democracy, human rights, etc., rule of law, because if they don't understand it, they won't have it. That's the connection between the courthouse, the Judiciary Committee, the judiciary itself, and the document that you want to talk about, which I'm delaying you
I'm
from
going to get
talking
to in a
about.
minute. I just, before we get to that, one or two more questions that are always people ask, I assume you. When you got on the Supreme Court, appointed by President Clinton, when you had your interview with him, famously you had been injured, unfortunately, in a bicycle accident, and then you kind of, did you get out of the hospital to go to the interview, or how did that, wasn't that kind of awkward to go do the interview when you were not in such good shape? You had broken some bones and...
I don't know, I can't remember.
Oh, okay. All right, so you get on the court, you get on the Supreme Court, and when you're on the court, how was the court, when you got to be a justice, different than when you were a clerk? You had clerked for Arthur Goldberg after you graduated from Harvard Law School, and was it much different being a justice?
Yes.
Then much better, I assume, being a justice than a clerk.
In some ways, yes. In some ways, no.
Okay. So, go ahead.
Okay.
So, of the most significant cases since you've been on the court, you've been on the court 20 years.
Yes.
Would you say that Bush v. Gore was the most significant in your tenure?
Yes.
And do you think that that case would have been the one that decided the presidential election had it gone another way? In other words, suppose you hadn't made that decision or you hadn't taken up that case, do you think the presidential outcome would have been different? Suppose the...
I don't actually. I mean, you can debate that, but I mean, if you read through the statutes, the way the president would have been selected, and you can look at the later efforts to count the votes that were cast in Florida, which I think the press did in the different scenarios, I think I'd come down on the side it might have been the same, but it wouldn't have been, it would have, if it had been the democratic processes that were working in a rather complicated way and not necessarily so perfectly. But that was not my job. My job was to decide that particular case. On that case, I was in a dissent. I dissented in that case. But I think the most important thing about the case, the person who said this was Harry Reid, who I think would have thought that maybe my side was right. And Harry Reid said the most remarkable thing about that case is something that's very, very rarely remarked. And that is, despite the fact that the case was important, and it was, and despite the fact that it was not popular, and it was not popular with at least half the country, maybe a few more than half, but nonetheless, it was not popular, particularly, and it was, in my opinion, wrong. And I think it is. I think he thinks so too. The remarkable thing is, there were not people killed, there were not riots, there were not paving stones thrown at people's heads in the street, there were no guns, people accepted it. Now, when I say that to a student audience, I usually add the following. I know perfectly well that a good percentage of you, when I say that, are sitting there thinking, and too bad there weren't a few riots. Too bad there weren't a few. And for those people, I would like you to turn on the television set, and I would like you to see what happens in countries where people decide their major disagreements that way. And we have decided to decide our major disagreements under a system of law. And that is a remarkable thing, that people actually follow that. It has a long history, and that history does begin 800 years ago with the document. I see Robert Wister here, it's his committee, and he's trying to say that that document and King John and those barons with over their hoofbeats or whatever it was, that is where that began.
Well, when 1215, at Runnymede, there is the famous Magna Carta, but why do you think it's so famous in the sense that it was abrogated by King John and the Pope very shortly after it was agreed to? So why did it become this big part of our legal history when it was actually never went into effect?
You know more about the history of the Magna Carta than do I. You have helped preserve the Magna Carta with the archives, because you helped the archives preserve that. That's the 1294 or whatever, 1297 that you had. And you're asking a very good question, because I wouldn't have known the distinction which you would have known between 1297 and 1215. But as you've pointed out, and others, Lord Coke, Blackstone, over a period of time, pointed to that document. Habeas corpus developed afterwards so that people could take advantage of that document. Now, what part of it is that the part they want to take advantage of and that's lasted? The part that says you will not be imprisoned or fined or disseized, I take it, taken your land taken away, except in accordance with judgment of your peers or the rule of law. That's it. And they pointed to that as the most basic thing. And that's what the founders, what Adams and others found so important. And it is a symbol of that which it contains. And indeed, that's why our Constitution has no person shall be deprived of life, liberty, or property without due process of law. Twice, once in 1787, and written again after the Civil War, so that it makes certain it applies to everybody in the United States of America. And that's what, it's such a simple idea, but that's what people are all over the world today trying to see if they cannot embody in institutions. But go back for a second to Bush v. Gore. Why is it so tough to embody it in an institution? Why? Because we mostly, it's the same question as with free speech. When I'm talking to students, I say, you know, you're for free speech. Everybody's for free speech. They're for the free speech of the people who agree with them. And when they hear somebody who really thinks something they disagree with, they say, oh, not that. Not that. Surely not that. I say, I hate to tell you this, but that isn't free speech. And so what Harry Reid is pointing out, that the remarkable thing about the rule of law in the United States is on matters that important, unpopular, and maybe wrong, because judges are human beings and can get things wrong. And do, they'll follow it. They'll follow it. And it's so easy to do it when you like it. It's so easy to do it when you think it's really not going to affect me. It's so easy to do it when, okay, great, it's wonderful, doesn't make any difference, who cares, either case. But when you really think it's wrong and it's really going to affect you, it's pretty hard to do. And it's that tradition that's been built up, and it's been built up over a long period of time. And the Magna Carta that we recognize is not the document of 1215, nor the document that you have over in the archives of 1297. It is those documents and those words, plus the fact that we have 800 years of practice in Britain and in the United States and a few other places where, for some miracle, it's built into a habit. It's built into a habit, into a custom, into a way of behaving, so that actually the people will do it when they don't like it. Now, there we are. That is rule of law. And it's that to which Blackstone and Cook were pointing, and that's what we're pointing right now.
So when our country was being created, the colonies were being put together, the charters for the colonies were being drafted by people like Cook. They actually helped in the Virginia Charter. And in there, the charters would say, the Virginia Commonwealth will have the rights of Englishmen. The people will have the rights of Englishmen. I think that is where the sense came in the United States or the colonies that they should have the rights of the Magna Carta because they had the rights of Englishmen, the Englishmen had the rights of Magna Carta. But when you're deciding a Supreme Court case, do you ever say to one of the other justices, well, let me go look it up in the Magna Carta? Or do you say, well, not really, we just kind of build on the Magna Carta? Have you ever written an opinion where you actually use the phrase Magna Carta?
I've talked about the Magna Carta, and the opinion I think was one of the more important ones that we wrote was when we had 4 cases involving Guantanamo. And in each of those cases, we had a plaintiff, or a petitioner probably, who was a prisoner in Guantanamo. And the respondent, or the defendant, was the President of the United States, or the equivalent. Now, you have a person like bin Laden's driver. Bin Laden's driver was not the most popular person in the United States. Against George W. Bush, the President of the United States, a very powerful individual. In each of those 4 cases, it was the prisoner who won. The last case, which I think was the most important, was Boumediene. And in Boumediene, the question was, could Congress suspend the writ of habeas corpus? The writ of habeas corpus is the writ which is not from the Magna Carta, but soon thereafter, over the years, and it means that if you get to a judge, anything, put a rock, and I had a case where there was a rock thrown out the window of someone who was being detained. The husband of a woman from the Dominican Republic was being detained by a customs officer in Puerto Rico, and he got a rock out the window, and it had a note on it, take this to the judge, I'm being detained illegally. The judge says, habeas corpus, bring me the body. Who is the jailer? And let that jailer explain himself as to what the reasons are, to see if that person is being held under the law or is being held arbitrarily. And he explained himself, the judge, that said then that that jailer is wrong, release him. Now, that writ of habeas corpus, there was a question, did it extend to Guantanamo? We first said the statute does extend to Guantanamo. Congress passed a special law saying it doesn't. And so the question was whether or not that writ extended, allowing them to come into court, to a prisoner in Guantanamo, where Congress says it doesn't. But there is a provision in the Constitution that says Congress may suspend the writ of habeas corpus in time of rebellion or insurrection. There was no rebellion, there was no insurrection, and what we said was Guantanamo is 90 miles away, and Guantanamo, if you look at the treaty, we control it. We control it. You may say sovereignty in Cuba, but the Cubans can't get it back unless we decide not to use it as a coaling station anymore, or what used to now called, I think, a naval base. And so we said, this is America, and the writ does extend. And in writing that, Justice Kennedy, who wrote the opinion for the court, wrote an opinion that says, let's trace the history of this thing. And right there is a whole paragraph, that the history begins with the Magna Carta and then fades into a period where it's going to be enforced, and the enforcement comes through habeas corpus, and this is not a minor thing. We have a Constitution that doesn't just guarantee democracy. It guarantees democracy, basic human rights, a degree of equality, it has separation of powers and so forth, and it guarantees a rule of law. With a document like that, this is a critical part, and therefore Congress cannot suspend this writ of habeas corpus. The prisoners in Guantanamo have the right to come into court and claim and try to prove that they are being held contrary to law.
Was that unanimous? I can't remember the vote.
No, it was not unanimous, but there was a majority that was for it, and I was on that side, so I tend to think it was unanimous, but that was
So let's suppose, like on Bush v. Gore, or anything where you're in the minority of 4 to 5.
I have been in the minority.
A few times, maybe, but when you're in the minority, you ever go to one of the justices and say, well, you know, I need a favor here. Could you just switch your vote a little bit? Maybe I could be on the majority then. You ever do a little trading like that?
No. No.
They just don't.
No. I say there are 2 unwritten rules that I think are important in the court. They're not written anywhere. What we have after a case, we meet in the conference room, we discuss it. We're alone. We go around the table, and everyone says what he thinks of the case. And the rule is nobody speaks twice until everyone's spoken once. Excellent. Fabulous. Not written anywhere, but we have discussion after that, but that's a very good system. The second rule is the cases are independent of each other. They aren't necessarily independent insofar as the principle of law has a relation one to the other. But the suggestion, you do this here, I'll do that there, no.
Doesn't happen.
Zero. It's called tomorrow is another day. I mean, you and I were great allies on case 1, tremendous allies. We thought we were so right. And now we have case 2, and we're absolutely at odds. How can somebody who thought so sensibly in the last case have lost his mind? I mean, that's what it is. That is what it is. So now you have brought up a case. If you want me to go on, I don't know if you do. Right?
Yes, go ahead.
Right. But the way I get your question often in a student audience is they'll say something that's sort of like what you said or something. I say, I know what you're actually thinking. What you're actually thinking is, aren't we junior league politicians? That's it. There are 3 things people think. One thing they think is that we take cases just whatever we would like. What fun this case would be. That is not how the cases are chosen. I'll spare you that. Then they think we just decide the cases the way we like. I just do whatever I like. I say, I never do what I like. Are you kidding? It's like being married. I mean, but in any case, you say, no, I don't just sit there and do it. But the third thing they think is that we are junior league politicians. I say, no. They say, but actually you'd say that. I say, well, look, 50% of the cases are unanimous, close 48% last year. The 5-4s were about 20% usually. In fact, there were 10 5-4 cases last year out of about 73, 72, something in the 70s. And of those 10, 6 were what you'd call the press view, the usual suspects, liberal, quote, conservative, with et cetera. 6 out of, yes, so I'm making a little progress here with my audience, but not that much, because then they say, but those were the important ones. And I say, well, those are the ones that the press said, well, you know, that's not quite, you're not going to go. So I say, okay, let's look at those. First of all, often, because the person has a sort of basic judicial philosophy that leads him one way or another, it isn't quite conservative liberal either. But look, the words liberty in the 14th Amendment and in the 5th Amendment, the words even the freedom of speech, they don't quite explain themselves. And we're taking cases really on the criteria pretty much that lower court judges have come to different conclusions on the same question of law. So they're open questions, they're very hard questions, and they're right on the borderlines very often. And look, we're not going to be able to get the answer just by looking up some prior case. We're not computers either. You say, you're just beating around the bush. I say, no, I'm not. I'm not. I've been there 20 years. I've not seen a decision like that. And I could even explain Bush v. Gore for you, decided on the basis of what I call politics. You and I worked in the Senate. Politics is, are you a Democrat? Are you a Republican? Are you, where are the votes? Who's going to be popular? No, 0. All right, you're going to say Bush v. Gore. I say, I need an hour on that one, but I can bring you around on it. I didn't mean politics like that. I meant ideology. Am I a free enterprise Adam Smith? Am I a Maoist troublemaker? You mean like that? Yeah, more like that. Well, I said, that's not right either. But there is something that's right. Something that's right is this, that I grew up where I grew up. You say San Francisco? Right. Yeah. I grew up in San Francisco. I grew up in the 1950s. I went to a public schools. I have had a long time in the law. I am the person I am. And by the time you're in any profession for a few years and a while and you practice it and have life experience, you'll have views. What kind of views? Very basic philosophical views. If you're a lawyer, jurisprudence, what is this document about? How does it relate to people? What's the country like? That's who you are in your profession, and you cannot jump out of your own skin, and you shouldn't. And therefore, on that basis, you will find differences, and you will find coalescing around certain basic things. But I don't think that's a terrible thing. It's a big country. We have 300 and some odd, 20 million, 10 million, 20 million people, and they think a lot of different things. And it is not such a terrible thing that on the Supreme Court of the United States, over long periods of time, you have people who think quite different basic views about how this document should be interpreted. It's okay.
So you're obviously, as you know very well, very articulate. You know what you're talking about very well. So why not let the American people see the justices when they're hearing cases? Why not televise it?
That's a good question, which you may or may not like the answer. I haven't actually had to vote on that. But and there are Supreme Courts that do let the television in. And there's a good argument for doing it. Why should the television be treated differently than the written press? The written press is there during the oral argument. So you're less familiar with the arguments the other way because I think the press is less familiar with them. No one understands an argument better than when it's in your interest. All right, but the reasons, the things that go the other way are several. One is there are several that are of some weight and then some that's of real weight. The one that's of some weight is, look, we're a symbol. It'll be in every place in the country. In the criminal cases, the neighbors won't testify, right, if they think on television. All right, that's a significant fact. The oral argument is not the argument. It's 5% of the argument. And they won't really understand the process is mostly in writing. Or People relate to people. Good. When you see a person on television, you relate to that person, not necessarily in the press as much. But our job is not to decide the cases for these two people in the courtroom. It is to consider and write or explain a rule of law that is for 300 million people who aren't in the courtroom. That will not come across on television unless they make a real effort. And some do, but not too many. All right? But then you want the real weighty reason, which I think?
Which is?
I have an awful lot of friends in the press who say, you think you won't be affected by the camera in that courtroom. Mm-hmm. You have the press there already. You think people will not behave differently. Mm-hmm. You think you're used to it, and you can just do exactly and say exactly what you want to do, which I do, by the way, sometimes to my disadvantage. But I do ask whatever you want. You think you will. Mm-hmm. You wait and see. You wait and see what happens the first time that you look at the television set and you see a total distortion of what you meant, making you look like a terrible idiot. I mean, some have claimed that the press, for example, keeps 2 pictures of each justice. You decide the way they want. You decide the way they don't want. It's Torquemada. You know, how did he get in there? And you've seen enough of television to think, maybe. So the true answer to that is, I don't know. But I do know that we are, in this sense, all a very conservative institution. And being a very conservative institution with a small c, we've taken over an institution that works well for the American public, pretty well, not perfectly. And it's worked fairly well for a long time, and I'm there as a trustee. And there were people before and people after. And the one thing the 9 of us have all been united on, whoever they were for the last 20 years, is we do not want to take an action that will hurt that institution. It's not for us. It's not for us. And as long as there's that big question mark over what would happen institutionally, people will hesitate. Now, I have no doubt we will go, others will come. There will be people there who have grown up so much in a world of television and internet and so forth that it'll be there, and people will be used to it. But you asked me about that issue during this period of time, and I've tried to explain it as best I can.
Well, I did a very good job of it. And let me just say about the Magna Carta itself, just add a note, there are actually 17 copies of the Magna Carta in existence. 15 are in British institutions, 1 is in the Australian Parliament, and 1 is at the National Archives. And there are only 4 copies of the so-called 1215 version. There was a 1217, 1225, and 1297 version, and some others. There are only 17 left, and the reason is it's 800 years. It's hard to, file things away and keep them, and lots of times they were burned and other things. But the Library of Congress now has on display one of the 4 1215 copies. It's very rarely in the United States, and I encourage everybody to take a look at it and see it if they can, in part because even though it didn't go into effect and was abrogated by King John and ultimately the Pope, it was the basis for the subsequent Magna Cartas, which did go into effect. The 1297 one did become the law of England and is still in the books of England. So without the 1215, we wouldn't have probably had the 1297. So if the Magna Carta had said that the courts of the United States should televise their proceedings, you would do it then, right?
Didn't King John say that?
I thought he did. I think
I do absolutely agree with you. There'd be a lot plus in the television. I wish people could. You would not have, if you'd seen the way in which the cases are argued and people respond. I suspect, though it's self-serving, but I think it's true that people take these very seriously. There's much more to be said, usually for the opposite side of the case than you're prepared to think, or I am when I go in. And you suddenly hear it, and people are wrestling with these difficult problems. And the school children particularly, that's who I'm focusing on, across the country could see that. That would be a plus. There's no doubt it would be a plus. And that's why people are divided on this issue. They're uncertain. And I'm saying there's too much uncertainty for a group of conservative people to run a risk with the institution. But go back and one thing where I certainly agree with you is look at the exhibition here of the Magna Carta. It's fabulous, partly because you see the document. You can see it at the archives, you can see it here. Partly because as you go through that exhibition, it will force you to think about the time that has passed, the people who have been involved, a few of the ups and downs. I mean, think of this country. I mean, we lived in a period, this country, of slavery. We had a terrible civil war. We had 80 years of government-backed racial segregation. We've had all kinds of things of ups and downs. And it's taken a very long time before those words in the Magna Carta have come to be accepted in the customs and habits of the people. And it's something they won't be. I would in my office, I had about 2 years ago a woman who was president of the Supreme Court of Ghana. And she is trying to bring into reality in that country more what she believes is a more democratic system and protection for human rights. And she said, why do people do what you say? Why do they do what the judges say? And there's no answer to that question other than to go into a little history and to say, look, it's not just judges and it's not just lawyers even who can get this done. The people who have to believe in it, that's Harry Reid, are the people who are not and believe it. Of the 311 million people in this country, 310 million are not judges and they're not lawyers. They're the ones. It's the people in the villages you have to convince that this is in their interest. Lawyers and judges might help you do that. They can talk about it, and they should. But they're the ones that have to be convinced. And go look at that history. And go look at the ups and downs. And that's what that exhibition will begin to make you do. And I think it's really a great opportunity to see the documents and to see them exhibited with other things. And I'm glad to have the opportunity to be here in part because I could see that.
The highest calling of mankind, I think it's fair to say, is public service, and I want to thank you on behalf of my fellow citizens and your fellow citizens for the public service you've given to our country. Thank you very much.
Thank you.
On behalf of this institution, which is our oldest federal cultural institution, I want to thank you both for an extraordinary event. It is really thrilling to see someone who's articulate in the private sector and also in public service, and someone who's in public service and is also articulate with all of us. To give you both extraordinary thanks for a wonderful and really instructive and even inspiring look at this even older 800-year-old institution. Thank you very, very much. I'm sure I speak on behalf of you and the many others who will see this later as it is streamed on television. Thank you very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.